Okay, right from the start, we got a housing dispute case Arbor One versus Rico and Wire. These cases usually look dry on paper, but trust meth drama here is all about inspections, tenant rights, and some serious court tug-of-war stick around because it gets heated.
Henry, on behalf of the defendant.
Good afternoon, Your Honor. Lauren Lehman for Tenant as well.
All right. And where are we? I hate to ask.
No. So we had inspections on 5/20, the COC inspections. There were a number of items that noted were failing for the inspections. They were supposed to come back out on 5/22 for reinspection. That was what we discussed at the pre-meeting. Property essentially a day and a half to collect some items. And then we will be on the 23rd to discuss where we are with COCs. Nobody showed up on the 22nd. We had guys there waiting for the reinspection, ready to go.
Here's what's happening. The city was supposed to reinspect these apartments, but just didn't show up. That's a big deal. If inspectors don't appear, tenants are stuck in limbo. Landlords get frustrated and repairs stall. So the judge is about to dig into why this happened.
So that's first and foremost at this point. I'm not sure. We were provided no notice as to why they would not be there on the 22nd. We were expecting that to occur. So our guys are ready with items having been corrected from the original list, from what they noted on the 20th, and nobody from the city showed up on the 22nd.
Anybody know why they didn't show up on the 22nd, Mr. Parker?
Your Honor, the inspector was standing in Carol Kunke's courtroom yesterday with counsel. He knew exactly why I wasn't there. Because there was a laundry list of non-callbacks that we didn't have. Judge Kunke has entered orders, or will be entering orders, we think, this morning, addressing the repair and inspection protocols for all of these buildings, because she's the same jurisdiction over all of those. But we were called back out to say, this is fixed, now look at that, this is fixed, now look at that. We're going to continue to do our inspections consistent with what we've agreed to do, and consistent with what we've been ordered to do by Judge Kunke.
I was in court. Joe and Myers and Gary Dunham were in court as well. I know that the city has other inspectors. We were expecting an inspection to occur. We had guys ready. We had no reason to know that they were not going to show up. We didn't know Jerry or Joe were going to be in court. I don't know what there was no reason for them not to have showed up. I didn't notice that they weren't going to show up, or to not arrange for other inspectors to come to the property to inspect, as we discussed.
All right. So I guess I want to make sure, and maybe I'll touch base with Judge Kunke. Is she issuing an order?
So
laying out everything, because then I don't want to interfere in any of that.
So Judge Kunke is entering an order based on what she explained on the record. She will be entering the order that repairs be done at the property, basically as urgently as possible that the repair is done. She will be entering an order with regards to tenant requests for relocation, things of that nature. Obviously, we don't know exactly what it's going to say, but this is what she indicated on the record, and as well as instructions to the city for timing of inspection. She took some issues with that.
Did you catch that? Judge Kunke is stepping in with new orders that could change everything: faster inspections, relocation rules, and tenant protections. What do you think? Should tenants still pay rent if their homes aren't safe to live in? Drop your thoughts below.
So she's going to require the city to inspect within 2 days of a request. And also, make themselves reasonably available for inspections if they're already on site for something, to inspect other work that may be ready. So she's going to be entering orders to that effect.
Do we know when she's going to do that? Or did she?
That we would possibly have a draft of that order at minimum today to see what it would look like. I think she's waiting on 1 or 2 exhibits that ourselves and legal services are working on in connection with that. I know I spoke with Lou about it, so I'm not sure.
Yeah, we're working on a draft that we should have over by, the end of today, and either today or I think next week she's planning to send out that order based on our draft and possibly yours that you send in, which will be covering, what she's dealing with in terms of focusing on repairs, as well as how tenants might be able to get relocation assistance, from their escrow amounts with the city, as well as whatever they pay to the landlord since September 17th, so that they can use that towards relocation for the tenants that are still, in the property.
All right, so what I guess I would want to make sure of what's contained in that order, because we have, this court has escrow funds.
Right, so one of the items that will be in the agreement that I think is pretty undisputed at this point is that Arbor One will not object to the release of the escrow that's being held by the city or the court. I believe that the city's agreement requires that like all parties agree to some extent, so, or something of that nature. So the order will clearly say that if they're electing the remedy to break their lease and move from Arbor One, that we won't object to those funds being released so that they can utilize that in finding whatever housing they may want to find.
Okay, so that will be contained within the order.
Yes, that will be involved with the order. Yes.
Okay, so what it seems like to me, and I guess what I'm gonna do is I'm gonna pause and I'm gonna try to reach out to Judge Kunke directly and just see exactly what she's doing, because if she's going to assume all of this, there's no reason for two courts to be doing it, in my opinion, so.
So to the extent that there are folks on your docket that have been relocated.
Wait a second, tenants moved out because of unsafe conditions, and now they're being asked to pay half rent just to hold their spot. That's like paying for Netflix while your internet is cut off. Fair dealer exploitation, you decide.
So one of the things that she indicated is folks that are being relocated are going to be paying half of their rent. I know that that's something that
Paying half of their rent.
or what it would have been in Arbor One. So if folks are being relocated with the intent to come back to Arbor One, so temporarily relocated, basically saying, I want to come back to Arbor One once I can be placed in a building with the COC, those folks are being required to pay half of their rent during their relocation period.
I don't think that was part of this initial order, but she did bring that up as a possible thing she was considering in the future. And bringing up those issues of tenants relocated to the hotels. We did have Mr. McGuire, who was relocated to the hotel, and it seems he's been relocated back to his apartment.
Okay. So I guess I'm curious. So where would, and I realize you don't have the order, where would this half rent be paid?
So Arbor One. And so basically the argument was, if we're relocating folks to a place that has a COC, whether it's, whatever accommodations are ultimately determined, Judge Kunke found it reasonable to say that they should be paying half of their rent. And so I believe that it is going to be in the part of the order. The last part that we talked about, no order, so that there's no direction to relocate folks or something in the order that says folks can request to be relocated but have to pay half their rent. So I believe that she decided that was going to be a part of the order, so it's going to be in there. I bring it up, and I know that this is something we talked about last time with folks that were on your docket having been relocated, establishing whether or not they intend to stay. And at that point, we should be discussing leases with those folks, or if they're planning to come back to the city side. And if that's the case, then they would be subject to that part of the order. So we just wanted to advise the court that would be something that would be happening with those folks.
Okay, got it. So for individuals, I'm just thinking about the cases that are before me. So for those individuals that relocated coming back, they would be, let's say their rent's $1,000. They would have to pay $500 to Arbor One.
Correct.
What happened? So, okay. What happens with the other piece?
The other piece of the rent.
Yeah, it's just not paid.
I think that is just taken as a loss to Arbor One. I think the idea is that.
Got it.
Yeah, so it's basically everybody's paying half. That was the.
And I think it'd be specific to their portion as well, too. If they're subsidized, they pay half of their portion, whatever that is.
Got it. They pay half of their portion. What happens with the subsidy?
I don't know if it was fully addressed.
Got it.
That's not something we got into.
Okay.
Up to the tenants.
Subsidy counts the hotel.
So I think what I will do, and so I could make this a very short hearing, it seems. Because it seems to me that if she's going to do all of that, that I'm not going to do anything and wait and see how it affects the cases that are before me. With reference, so for example, just taking by way of example, the escrow order, that really, I think in some ways negates the escrow order, right? For those individuals that would fall within that classification. Would you agree with that?
It negates your escrow order.
Yeah, because so if an individual is intending upon coming back, what the circuit court is saying, they need to pay half of their rent to Arbor One and Arbor One West. My order would indicate that they pay nothing, that they pay everything to the court.
Right, so yes, in essence, it would negate that, and then for the folks that are leaving altogether, they would get it back, so yes, in essence.
So of the cases that I have, how do I sort those people out?
For the folks who have been relocated versus, so we don't know the extent of everyone's desire to be relocated or staying permanently or temporarily. Some folks have also found their own housing at this point. So I think we would need to get a list of folks that have been relocated by Arbor One and, connect with them about, to the extent they intend on staying where they are, or if they are intending to come back to the city side. And if they're staying where they are, then we can deal with leases. And if they are intending on coming back to the city side, once there's a unit available that has a COC, then they would be required to pay their 50% of rent.
And do we have any people still in hotels that were relocated to hotels?
It's my understanding nobody is still in a hotel.
Okay,
Everybody's been relocated somewhere else.
I believe Mr. McGuire was relocated back to his original tenancy.
On the
So
city side,
I believe so.
I can inquire into.
So here's the pivot. This judge doesn't want to clash with the higher court translations, putting the brakes on his own rulings until Judge Kunke finishes its power, shuffle one court stepping back, so another can take control.
What's going on there? I don't know why it's stepping back, what's happened there, but inquire and get the court information if that's what you're looking for, Your Honor.
Well, I just want to make sure that the 42 I have, that the orders that are consistent with what's been ordered at the circuit court. That's what I want to make sure of. And I guess we can do that sort of on a continuum basis, or what I could do, and what I may be inclined to do, is to just issue a stay on these proceedings before me and just await the final resolution in circuit.
Our next visit with Judge Kunke is on
The 9th of June.
In lieu of a stay, could we perhaps adjourn proceedings for, say, 3 weeks to see we can sort everybody out? Who's going to do what, when, and where, and then we can maybe get some dismissals or CODs or settlement agreements in place?
Something in place
Yeah.
on these. That's fine with me also.
Okay.
I don't have a problem with that as long as the repairs are being made and the tenants. It sounds like through what Judge Kunke's doing, the tenants are being taken into account in terms of what's happening. So,
I think a stay might work better because I just don't know how long this stuff in circuit court's going to go on for. But I think, once that's over, it's mostly going to resolve any issues that exist for all these tenants in this report, I believe.
well, why don't I do this? Why don't I adjourn it out to the 27th of June at 11? All right. Allow that to kind of take place if necessary, and then do that. All right.
Good. Thank you, Your Honor. In lieu of you having to bring your staff out on the 28th, I have a pamphlet showing a lot of
the
Yep.
things. All right.
So what Mr. Whitman is providing is photos, taken of units in both of these buildings. At this point, we're dealing with situations where many of these units are ready to go, turnkey, ready. There are remaining items on the correction orders list, but not necessarily because they weren't corrected from the original list, but upon inspection, the city added more items to the list. And so we're obviously, you've made your decision with regards to having Hunky over here. This was, we're going to be arguing that these buildings are ready for the minimum temporary COCs. There's no reason that folks should not be in those units, and a correction order for the units that still have some items that need to be done. List be provided of a 30-day correction order. These units are not to be occupied until corrected, and a temporary COC provided for the building. At this point, we need to get folks in these units that are ready to go.
But did Judge Conkey address the issuance of the temporary CEOs?
We did talk about it. She, at some point, it's been discussed. We did get it very clear. Seemed at some point she was inclined to an interim solution on one side of, asking about the units that were ready to go. I don't think that we were able to explain to her that we would request a 30-day, correction order for some of these items that, the temporary COC could be in place, and that the correction order could say that some of these units should not be occupied until those items are taken care of off the list. But no temporary COC was ordered by Conkey at the time, but we also have these photos as of today. And so we're going to be presenting her with this same information that there's no reason folks shouldn't be in there. We're talking about items in some of these units that folks recently moved out. One of the things we talked about at the meeting with the city was that, what do we do if you come out for inspection and somebody moved out of their unit, 5 days before? Are you going to ding us because we're still turning that unit? A lot of these items that have been presented to the court in the most recent submission by the city are in fact some of those units and issues that we're still waiting on inspectors to come out and inspect. We still have inspections scheduled out for a lot of these units. So these items are not things that should hold up a COC or a temporary COC.
And there this case adjourned until late June, but don't let the delay fool you. Behind these pauses are tenants waiting for safe housing, landlords battling over money, and courts trying not to step on each other's toes stick around because the next hearing could make or break this entire housing fight.
Getting to the building. These items can still be corrected, and it can be ongoing while folks are able to be in these units that are perfectly fine.
All right. Okay.
We are.
So what I will do at this point is I will cancel my visit on the 28th to the unit, given these being here. And also given the fact that it seems, again, I don't want to interfere with what the circuit court is attempting to try to do, or try to do something that might be inconsistent with that. I think it's going to cover, it sounds to me, based upon what's being explained, is going to cover in the same way that I would the cases that are before me. So, okay.
Thank you.
So what I'll do is I'll adjourn this out to June 27th, 11 a.m. for a status conference.
And then for the tenants in this court, should they continue to pay escrow for June?
They should. Yes, they should pay their escrow for June. And then, because as I understand it, given what that order circuit court may look like, depending on then what that tenant decides, there's going to be some disposition of that escrow. All right.
Thank you, Your Honor.
Thank you, Your Honor.
The other aspect to it is, and I'd rather not refund it because it was the only way we were able to at least start the inspections. We still have that 65,000, I think it is, sitting here.
Okay.
And that, I mean, the intent of that, as I'm recalling, was to pay various invoices of the city regarding some of these inspections. So,
I think they asked that be turned over to the city.
well, that was the problem before. You want that turned over to the city, but when we tried to do that, we were told couldn't do that. They didn't want to just take a lump sum.
it would have to be applied to individual.
Right, but nobody knew what those were. And so,
Why don't I suggest this? I can, obviously it's a holiday, but, because we have to figure out what we're gonna do with our escrow too, obviously. Have the, Mr. Myers break down the list, submit that list to the court, for what costs go where, that might be the approach.
I mean, from our perspective, we would have no objection to the money just being applied to inspection fees. I think that that's been the biggest kind of holdup in getting some of these things done. And I think that that would help expedite making sure that things are done.
right, no, so if anybody recalls the hearing, the sole reason that money ended up here is because there were these inspection fees due, and then there was an indication that further inspections weren't going to be done because these others had to be paid. And then I had to go through and try to figure out what the amount was that needed to be paid. And then I got a figure which was opposite of what I thought. I actually got a lower figure from the city than I did from Arbor One as to what was owed. So I took the higher figure, said, put it in escrow. Now it's there. When I also suggested that they just turn over the lump sum amount, that was sort of rebuffed because it was said, as I'm recalling, that they, whoever they are, don't like us to take it that way, that it has to be applied. So I don't have a problem if the city were to council get together while this is going on and come up with a list of what invoices are to be paid. Give me a total at the end that's then to be released to the city. I don't have a problem with that, but everybody just needs to be in agreement what needs to be paid.
For the record, I think your recollection is accurate.
Thank you. Still haven't lost it, I guess. All right, so if you guys get that together, give me an order for release of that. I don't have a problem. I just didn't want everybody losing sight that that's still sitting there. Okay? Thank you, folks. 27th at 11.